everyone, today we will do legal dictation exercise number 24. So ready? Start. The aforesaid resolution of the full court meeting with the recommendation was forwarded to the state government, and the state government passed an order on 3/7/2003 whereby the services of the petitioner was dispensed with as recommended by the Honorable High Court. This action was taken in exercise of the powers vested on the competent authority under sub-rules 3 and 4 of Rule 15 of the Judicial Service Rules. Being aggrieved by the issuance of the aforesaid order dated 3/7/2003 dispensing with his service, the petitioner filed the present writ petition on which notice was issued. On service of notice, the High Court has entered appearance and also filed the counter affidavit explaining the circumstances under which the service of the petitioner came to be terminated. The petitioner appeared in person before us and submitted that the aforesaid order issued by the government of Jammu and Kashmir of 3/7/2003 is illegal and without jurisdiction, as the said order was not issued by the government but was issued by the government of Jammu and Kashmir. He also submitted that the recommendation of the High Court as communicated under letter dated 5/5/2003 is also illegal and liable to be set aside, as the High Court terminated the service of the petitioner under the aforesaid order, for which no power is vested on the High Court to dispense with the service under its own order. It was also submitted by him that he had completed his 2 years probation period on 23/8/2002, and since there was no order of extension of his probation period prior to and immediately after 23/8/2002, he should be deemed to have been confirmed in the judicial service, and therefore his service could not have been terminated on the ground that he was on probation. The petitioner also submitted that his service was terminated on the ground of an alleged misconduct, namely pendency of a criminal complaint and his alleged behavior with subordinate staff, and therefore the said order of termination of service was in the nature of a punishment by casting a stigma on the petitioner, and therefore illegal and without jurisdiction, as no opportunity of hearing was given to the petitioner prior to passing of the order of his termination. He also submitted that since he was granted increments by the respondent, it is proved that the respondents were satisfied with his service, and therefore the order terminating his service is without jurisdiction. Counsel appearing for the respondent, the High Court of Jammu and Kashmir, however, refuted the aforesaid submissions and placed before us the records of the High Court connected with the service of petitioner and also the records leading to his termination from service, he submitted that the petitioner continued to be on probation even after 2 years, as no order of his confirmation was issued or passed by the respondent, and that his service was terminated within the 3 years period of his probation on the ground of unsatisfactory service. He denied that the impugned order is stigmatic or in any way punitive, or that there was any violation of the principles of natural justice. He submitted that since the service of the petitioner was terminated on the ground of unsatisfactory service, there was no question of drawing up of any departmental proceedings against him. Thank you.